that pillows were put over their faces, that they were removed from the hospital without ever seeing their children. This, you're saying, is true?
In some cases, yes, I'm sure it was. I can't speak for all, but I suspect, as I heard it from my own patients of the day, was that the practice in labour ward at Crown Street, for example, was to whisk the babies away. I think the midwives felt that that was a kind thing to do, however misguided it might seem with the wisdom of hindsight. I think they really believed that they were doing the right thing by the young women concerned.
And on Diane Welfare's central accusation that social workers were among those who systematically broke the law, you say?
I'd have to challenge that. I'd have to challenge that.
Diane?
Yes, I'd like to respond to that. I wanted to say to Elspeth's comments that irrespective of parental opinion or society's opinion, it was the social worker's responsibility toward the unwed mother to provide her with the options and alternatives to enable her to keep her child. It was actually against the law to promote adoption in any way, shape or form above keeping that child. It was not the responsibility of the nurses or the hospital administrators or the doctors or the parents to advise the mothers who were unsupported, and there's no doubting that many parents didn't want their children to keep their daughters to keep their children, but it was the social worker's responsibility once the mother became a client to advise her under the regulations of the Child Welfare Act. The mother was to be provided with information regarding financial assistance under the Child Welfare Act, number 27, financial provisions, alternatives, temporary foster care. She was supposed to be advised of the risk of future regret, of grievous harm she could do to herself if she decided upon adoption. And only if the mother insisted upon adoption after all her alternatives and options were made available to her, then was the adoption to proceed.
And you're claiming this didn't happen.
I'm sorry. As far as I was concerned, with my clientele, I pointed out what the options were. The point I'm trying to make is that the options were extremely slender. For example, the Child Welfare Department in New South Wales did provide a pension for single mothers and their child, but only after the young woman concerned had taken out affiliation proceedings against the father of the baby, a procedure that a number of young women were not willing to do. Furthermore, if
would you explain what that meant?
Oh, it's what's referred to in popular speech as a paternity suit. In other words, the mother had to make a claim against the father before becoming eligible for the allowance that the Child Welfare Department paid.
And I believe that used to involve lining, the young man would often line up with a group of his friends and say, well, we were all fathers.
The standard defence was that the young man would bring his friends along who said, oh, well, we all slept with her. I mean, it was humiliating. It was a terrible procedure that many women wouldn't have even considered. But I certainly raised these possibilities. I think that the